Dear students, earlier in this lecture we had discussed about some special accounts in the procedure for opening a bank account. So now the topic is special accounts, so we'll be talking more in detail about some of these special accounts. So the first type of a special account is the account of a minor. So minor is a person who has not yet attained the age of 18 years, and in case a guardian is appointed by the court before he or she completes 18, he remains a minor till the age of 21. Okay, so this is the definition of a minor. As far as the account opening procedure goes, the account can be in the name of the minor or two or more minors jointly. And for the operation of the account, it is operated by the guardian, or if the minor has attained the age of 12, he can operate the account. Now, what about loans, advances, or OD facility? So, if loans, advances, or OD facility is extended to minor, bank should know that there is no legal remedy for that. Any contract with minor is considered void, so banks cannot seek legal remedy for advances, loans, or OD given. Pledge or mortgage. So even if the minor wants to pledge or mortgage his property, it has no meaning since the minor cannot do so. In case of default, a minor cannot be sued. And in case of death or insolvency of a minor, the balance can be withdrawn by the guardian. And once the minor attains majority, or he crosses the age of 18, or in case the guardian is appointed and he crosses the age of 21, the minor account should be closed and a new account should be opened in his or her name. Some additional precautions would include: people should remember, banks should remember, the contract with the minor is void, and if a minor is appointed as an agent on behalf of his principal, he cannot be held responsible for the actions of the principal. Okay. So moving on, the next type of special account is married women. So as already discussed, for account opening, especially for a woman in Parda, her signatures should be attested by a responsible person. And as far as the account operation is concerned, she may operate her own account. In case she opens a joint account with her husband, banker should get clarity on who will operate the account. In case of a Parda woman, someone responsible should attest her signature while she places request for withdrawing amounts from her account. Okay. Regarding loans and advances and overdraft facility, banks need to be very careful while advancing loan or overdraft to a married woman. A married woman's own property, which is also called Sridhan, will be available to bank and not her husband's. So her husband cannot be made liable for actions of the married woman. If loan is to be granted, bank should ensure that they secure sufficient property of hers, property which is in her own name. And banker should incorporate a free will clause in loan or overdraft agreements, because later on she should not say that she did this under pressure from her husband. So bank can anyway not recover this from the husband. So pledge or mortgage, bank should secure enough by pledge or mortgage while granting loan. And please remember, in case of default, she cannot be imprisoned for judgment debt or cannot be declared insolvent. So banks have to ensure there is enough backup before they advance anything to her. And in case of death or insolvency, anyway insolvency question doesn't arise, she cannot be adjudged insolvent. And clarity on who will get the settlement amount has to be given in case of death. As far as precautions are concerned, if she acts as an agent on her husband's behalf, bank should exercise double caution, because she might execute something and she cannot be held responsible. And so since it is little complicated, Bank should be doubly careful. And then the next type of special account is joint account holders. So when an account is opened in the name of two or more persons, it is known as joint account. And for account opening, application for opening an account must be signed by all the persons. And regarding operation of the account, specific instruction in writing about the mode of operation should be given. That is, persons who will sign withdrawals or checks. And without instruction, banks will honor only those checks which have everybody's signature. And any joint account holder can stop payment of check, and banks should follow the direction. Regarding loans, advances or OD, in case of overdraft, concurrence of all the account holders is a must. And in case of default by the joint account holder, any amount outstanding can be recovered from any of the account holders, and banks make all the parties liable jointly or severally to the extent of their liability in the joint account. Okay, as far as death or insolvency is concerned, balance can be withdrawn by the survivors. In case of insolvency or death, operations of this account should be stopped immediately, and if required, a new account can be opened. And regarding account closing, if any party gives a notice of revocation of authority, the bank should suspend operation of this account. Okay. Then the next type of special account is partnership funds. So partnership is a relation between persons who have agreed to share the profits of business carried on by all or any of them acting for all. So this is a standard definition of partnership. So let's look at account opening. So account can be opened with the names of all partners. Or it can also be opened in the name of the partnership firm. So in case of latter, the banks should review the partnership deed. And other precautions also should be taken. They should also review the number of partners, name of firms, all these whether names are tallying. So this should be properly reviewed in the partnership deed. Bank should prefer that all partners should join them while opening the account for the firm. And the specimen signature of each and every partner is also requested for record. And a partnership letter is also requested from the partners. This generally has the names and addresses of all partners. Specimen signature. It also has the details of business carried out by the firm. And also the names of partners who are authorized to operate the account on behalf of the firm. So as far as account closing is concerned, if any party gives notice of revocation of authority, the bank should suspend the operation of the account with immediate basis. Moving on, the next category of special account that is opened with banks could be for joint stock company. So joint stock company is incorporated, by definition, it's an incorporated voluntary association of persons in business having joint capital divided into transferable shares of fixed value along with the features of limited liability, common sale, perpetual succession, and so on. So this definition, I think most of us are aware by now. So as far as account opening is concerned, bank should go through important documents like certificate of incorporation, certificate of commencement of business, memorandum of association, articles of association, and also obtain a copy of all of this. And it should also obtain a copy of the resolution passed by the board of directors regarding appointment of the banker. And it should also get details of the persons who are authorized to operate the bank account and persons who are authorized to execute documents on behalf of the company. And in case of loans, advances or OD, the purpose of borrowing is restricted in the memorandum of association, so that needs to be checked. A certified copy of resolution of BOD is requested again when loan is requested. Okay. If it's a listed company, the borrowing cannot exceed the aggregate of paid up capital plus the free reserves. Please note, this is very important. It cannot exceed the paid up capital and its free reserves. Why is this? Because in case of default, they will be able to recover, hopefully they will be able to recover from this amount. Okay. And some precautions that need to be exercised. In case where director has personal account also with the same bank, caution should be exercised when there are endorsements and amount is credited to director's personal account. So they have to be very careful because the director is authorized to um, operate the account, execute documents. So if there is endorsement made by him to his own personal account, questions need to be asked. In case of doubt, it should be declined. The transaction should be declined. The next type of special account is non-trading institutions. We spoke about charitable institutions, clubs and societies, libraries, religious institutions and so on, which are not engaged in trading activities. So bankers should ensure applicant society or the club or whatever the institution is properly incorporated either under Societies Registration Act or Companies Act or Cooperative Societies Act. A copy of the society's own constitution, charter or memorandum of association or rules or bylaws should be obtained by the banker. A copy of resolution passed by the managing committee to indicate that the concerned bank is to be appointed as the banker also should be obtained. And as far as the operation of the society's account is concerned, resolution to indicate names of persons who are authorized to operate the account should also be obtained, a copy of that. In case of death or resignation of the person authorized to operate the account, the bank should stall any operation till the other person is nominated. And again, as a precautionary thing, in case a person authorized to operate the society's account also has his own personal account with the banker is under obligation to ensure funds are not credited to his account. So due diligence has to be exercised exactly like the joint stock company. Moving on, the next type of special account is Hindu undivided family. So joint Hindu family is governed by Hindu law, which is a compilation of Hindu practices and customs prevailing by time and traditions. Hindu, Sikhs, Jains are communities who fall under Hindu undivided family. The senior member of the family or the manager or he is referred to as a Karta. He is alone empowered to handle the affairs on behalf of the family. As far as account opening is concerned, as already discussed, it must be executed by Karta and by all major co-partners, that is all major partners in their personal capacity to make them all liable. And instructions of opening account must be obtained in writing. And operation is generally carried out by the Karta. And in case of death or insanity of any of the co-partners, it is advisable to open fresh account opening form along with fresh HUF for Hindu undivided family declaration. The last category, this is not exactly an account, but this talks about executors and administrators. So executor is a person named with the will of a deceased person, and he is a person who is to look after the property of such a person. So executors, this is possible only if a will is prepared. And administrator is a person who is appointed by the court in case a person dies without having a formal will. So the account of the executor is to be opened only on production of a probate or copy of the deceased's will under the seal of the court, together with certificate that the will has been provided. And as far as an administrator is concerned, he is required to produce a letter of administration being issued by the court for opening. And so with this, we come to the end of Unit 4, and we'll take up some specific topics from previous year question papers. Thank you so much.